Welcome to this Landmark Chambers webinar on COVID-19 and university students renting a room you can't use, a perhaps unnecessarily long and unwieldy title for our seminar. We're very pleased to have so many people joining us today. I confess it's always a bit of a gamble when you put these things on, because things that you think might be interesting, you discover that nobody else in the world thinks is interesting, or things that you think that are perhaps not that exciting, you end up with large numbers of people joining in. So it's always glad to know that we're doing something that people actually want to hear about. We hope you're going to find today useful and informative. My name is Justin. I am at least notionally in charge today, and I'll be chairing it. My colleague Admas is going to be taking over from me a bit later on to do all the exciting stuff today. We were going to be joined by Fiona, who was going to be talking as well, but unfortunately she's had to go to court. So we've had a bit of a change around. And the way we're going to divide today up is I'm going to talk first, and I'm going to talk primarily about what's called the private law issues arising out of COVID-19 and renting rooms. So I'll be looking at issues arising out of breach of contract or frustration from both halls of residence style accommodation perspective and also private rented sector perspective. And then I'll hand over to Admas, who's going to talk about the public law implications. He's going to talk about the regulatory side of things, and then he wants to also talk a little bit about rent strikes and the legality of rent strikes or otherwise. In terms of housekeeping, your microphones are all automatically muted, so you don't need to worry about adjusting any settings on your computer. It's intentional. We're very, very happy to take questions throughout the session. The easiest way to do this is in the question and answer box that should be, if you're all using the same version of Zoom as us, it should be in the middle of your screen at the bottom, Q&A and then 2 speech bubbles. Typing in there is the best way forward. We'll try and answer as many questions as possible at the end of the presentations. If during something that I'm talking about, Admas spots a question that's obviously relevant, he may interrupt me and ask me to answer it then and there. Likewise, when he's speaking, I may do the same. But I suspect that the easiest way to deal with questions will be at the end, because with 400 odd of you, even if only 10% of you decide to ask a question, that's a lot of questions to get through. The webinar is going to be recorded, so you will receive a link to the presentation and the recording in due course. And if for any reason you lose connection at any point, just click on the link that you used originally and it should bring you back in. I think that is it in terms of housekeeping. So let's see if I can take over and get these things to work. There we are. There's the two of us, myself talking about private law issues, Admas talking about public law issues. And another photo of me. Seems to me there are too many photos of me. Let's have a little bit then, a talk about what I want to talk about. The frustrating bit, I suspect, for many of you who are going to be listening to this, is that neither contract law nor landlord and tenant law are going to give you a particularly clear answer to the problems that are arising out of not being able to access the rooms that people that you've paid for. Or if you're a provider of accommodation, as I know many of you are, they don't give you easy answers to whether or not you've got to refund people or let them out of their contracts. This isn't an area where you'll be able to go to a particular book or go to a particular case and just say, well, look, that's the answer, that's what you have to do. From a private law perspective, so much of what the answer is depends on what the contractual arrangements are in each individual case. And as you'll all know, there's no such thing as a standard assured short-hold tenancy agreement for those students who are renting in the private sector. And there's a myriad of different forms of tenancy and license agreement used for university-provided accommodation, depending upon whether or not it's halls of residence provided by the university, whether it's private accommodation, but in privatized halls of residence, etc., etc. And that lack of a simple answer makes my talk, I suspect, one of the more frustrating ones you're going to have to listen to. It seems to me that there are two main areas I should talk to you about. One is the doctrine of frustration, which is when contracts come to an end because of something unexpected or unforeseen. And secondly, and I think perhaps more interestingly, issues around breach of contract from both the tenant and the provider of accommodation that it seems to me, are going to arise and may indeed already have arisen in some cases. There's a difficulty as well that I want to touch on, which is about being careful what you ask for. The general position from students, and I have to say not just students, but also many of their parents who are guarantors who in practice are paying these rents. The general position seems to be that they want to get out of paying for it as quickly as possible because they can't use the rooms at the moment. There is a difficulty with that one needs to be careful with, which we'll come back to later, because it is potentially quite difficult for students to just get out of their contracts, and if they did get out, there are other obligations that will arise that they may not necessarily find that attractive, to do with what kind of property that they've left in the rooms, etc., etc. The plan is I'll talk for 15-20 minutes or so on that. Admas then pick up on his bits, and that gives us plenty of time for questions at the end. But as I say, I apologise in advance for the fact that there are no simple answers, and you're likely to be quite frustrated by the end of my talk. Now, let's move on. Here we go. I want to talk about the doctrine of frustration, because that it seems to me the first port of call to think about here. I simplify enormously, and for all the other lawyers on this call, I apologise for some of the simplification, but I appreciate not everyone on this call is a lawyer. You have to assume that there's no clause in your contract, whether it's your tenancy agreement as a private landlord, or whether it's your license agreement as a university halls provider, whatever it's going to be. Assume there's no term in your contract that covers a scenario of a pandemic or of the government imposing restrictions which appear to have the effect of preventing people from moving around the country. In English law, where you've got a situation where the contract just doesn't envisage and doesn't make provision for something, and the something in question is an event which occurs after the formation of the contract, which makes it physically or commercially impossible to fulfill the contract, or which transforms the nature of the obligation under the contract into something radically different, then you get into the realm of what's called frustration, which is a judge-made doctrine which provides in very simple terms, and again, apologies to many of the lawyers listening to this for how simplifying some of this is. In very simple terms, when a contract is frustrated, it comes to an end. You have to pay what was due under the contract up to that date, but going forward, you're released from your obligations. That is the nature of the doctrine of frustration. And that has been the go-to, I suppose, answer for most people thinking about what happens to student accommodation in this context. The argument goes that the pandemic or the lockdown restrictions are something which have occurred after the formation of the contract, and they make it physically or commercially impossible to return to live in the property. Therefore, the contract is frustrated. But is that right? I just want to spend a little time thinking about this. On the question of timing, because most university accommodation contracts, if they're private sector, run from June or July for 12 months, or if their halls tend to run from September to October for 12 months, we're looking at two different cohorts of student who might be affected by the pandemic. For those who had their tenancies in 2019, so PRS tenancies, private rented sector tenancies, starting June, July 2019, running for a year, or halls licenses running from September, October 19 for a year. The position that they seem to be in is rather different to the people who've got contracts that started in June, July 2020, or license agreements starting September, October 2020. Because if you signed up to your private rent sector tenancy in June or July 2019, or you took your license to occupy your university halls accommodation in October, September 2019, then plainly the instance of the pandemic is an event that's occurred after the formation of the contract. You can slightly debate when a pandemic has been declared. The WHO puts it in late December. the position seems to be being taken in English law that it's being treated as being January, February in this country when it got here. But in any event, December 19 or January, February 2020 is obviously after the people entered into their 2019 tenancies or 2019 licenses. So on the face of it, that the pandemic is capable of being an event that gives rise to frustration. But those contracts, of course, those 2019 contracts, are almost always for a year, and they've just expired by passage of time. So there isn't really any need to get out of them in any way, shape or form. There may be an argument about where money has been left unpaid under those contracts. Is it due to be paid? Or where money has been paid, can it be refunded because the contract was frustrated? But those contracts seem to me to be likely to have ended naturally through passage of time. Where I think this is more difficult is the people who started university this academic year. So they took their tenancy agreements in the private rented sector in June or July 2020, or they took their license agreements from their halls providers in September, October 2020. Plainly, the pandemic per se is not an event that's occurred after the formation of that contract. The pandemic was already in existence and ravaging the country. So if you are a current student trying to get out of these situations, then what you need to know about, it seems to me, is you need to look at whether or not the lockdown restrictions can be said to have been the event post-contract which have changed the nature of the obligation. And the lockdown restrictions themselves, as I'm sure you will appreciate, have changed dramatically over time, which makes this a very, very difficult question to try and trace through. As things stand at the moment, in England at least, the regulations that impose the current lockdown do not prohibit people from moving from one property to another. It is lawful, as far as I can see, for a student who is presently living at the family home, but who holds a tenancy or license in another country, in another city with a university or a private tenancy, to return to that property that they've rented. The requirement is that the travel is permissible if there's a reasonable excuse. Reasonable excuse is not exhaustively defined in the regulations. Guidance gives you some examples of it, but the guidance is not law. The Secretary of State's guidance and Matt Hancock in particular statements that he keeps making are not law. They are merely the government's view about what the law should be. As things stand, if you are a student who is in your family home in Southampton and you have a tenancy of a property in Manchester, it is lawful for you to return to that property so long as you have a reasonable excuse. Now, what is a reasonable excuse is something that is likely to be quite fact sensitive. But for example, I could imagine that if you were unable to study in your family home because it's now overcrowded, that could be a reasonable excuse. I can see that if there are health reasons to do with your own mental health, why you want to be away from your family, that could be a reasonable excuse. If you need access to material, library facilities and such like, that could be a reasonable excuse if they're not available to you online. Because it's not unlawful to return to your property, it's not going to be possible to say, it seems to me, that all contracts, whether private or hall style, are frustrated. It's a very, very fact-sensitive question. There are two, I think, particularly difficult scenarios to think about, though. One is students who live with their family in England outside of term time, but whose university is in Wales, and students who ordinarily live outside of the UK, but who have tenancies or licenses for properties in England or Wales. At one stage, and I'm not quite sure if this is true still, because I confess I haven't been able to trace down the most up-to-date version of the Welsh lockdown regulations. But at one stage, it was certainly unlawful for people to leave their homes in England to go to their second homes in Wales. And so for that period of time, there may well have been a good argument that students who were living with their family in England, but who had property that they were allowed to occupy by virtue of a tenancy or a license in Wales, may well have been in a position of having their contract having been frustrated. For those who live abroad, it seems to me that there's also quite a strong argument about frustration, because of course it is impossible to return from most countries. There are very, very few air corridors or air travel corridors, as they're called at the moment. And if you are in country A and country A does not have a travel corridor with us, it is simply not possible to return to the UK. That seems to me, again, to be capable of being a frustrating event. It may be that that argument ceases to become available to people as travel corridors open up again. But even then, the current plan seems to be that although the corridor would open up, you'd still have to pay to quarantine yourself in a hotel for a period of time. And so I suppose then the argument becomes, is it nonetheless frustrated? Because although it's lawful to return to the country, it's practically impossible because you don't have a spare £2,000 to pay for the accommodation in the hotel. I did warn you at the beginning, this is going to get quite frustrating. And you can see why, because the situation of the 18-year-old in Southampton who's going to move back to Manchester is very different to the situation of the 18-year-old in Bristol who might have to move to Cardiff, or the 18-year-old in Perth who might need to fly back to London. And the fact-sensitive nature of those discussions makes this a very difficult conversation to have. For halls of residence, it seems to me that there's a potentially further argument as well. Many halls of residence, as I understand it, are simply not open at the moment. As I understand it, the broad position is for those students who were unable to return to their homes during the Christmas window, they stayed open. But for anybody else, the universities or the providers are not allowing them to return. Now, I appreciate there's likely to be a massive variation from across the country and between universities and private providers of halls. But in that broad situation, where you've got a situation where the university or the provider is not allowing you to return, is that frustration, or is that merely a breach of contract on the part of the provider of the accommodation? I think it is likely to be breach of contract rather than frustration, and I'll come to why that matters in a moment. There hasn't been any UK-specific case law about coronavirus and student accommodation, or indeed coronavirus and lettings generally. There was, though, back in 2003, a very, very interesting case in Hong Kong about the doctrine of frustration, which is very similar in Hong Kong law to English law, when they had their SARS outbreak. In the case that I mentioned on the slide, the first named party is the owner of the building, and the second named party has a 2-year lease of a flat in the building. During the SARS outbreak, the Hong Kong authorities imposed effectively a 10-day lockdown on the building, one of the effects of which is that if you're inside, you can't get out, and if you're outside, you can't get in. In those circumstances, if you're prohibited by the government from entering the property that you are renting, do you have an argument that your contract has been frustrated so as to enable you to get out of it? And that's what this case is about. And on the facts of this Hong Kong case, they hold no, that wasn't frustration. It was a 2-year lease, and it was only a 10-day interruption. And a 10-day interruption was held to be not sufficient to interfere with the right to enjoy the property for 2 years. Now, in practice, I don't think the tenant wanted to enjoy it for 2 years. Reading between the lines, the tenant had clearly decided that as a result of the SARS outbreak, they simply didn't want to be living in Hong Kong anymore and were going to move somewhere else. So they were trying to use SARS as a reason to get out of the contract, and it didn't work. How far you can take that in any given case over here is obviously how long's a piece of string. 2-year contracts for tenancies in the private rented sector or 2-year contracts for licenses for university halls are, I would not say unknown, but I would certainly say very, very rare. The reality is they're normally 1 academic year for halls or 9 months or so for a rental agreement in the private rented sector. And clearly it's been a lot longer than 10 days. On the other hand, in the Hong Kong case, it was actually against the law to enter the building or to leave the building. And it hasn't been made against the law to return to your property here. It's just been subject to a reasonable excuse defence. I should just say in passing, there's one other idea that opened up to me when I was reading that Hong Kong case again. This won't apply to university halls, and it probably won't apply to private sector providers of halls accommodation either, but it would apply to private sector tenancies of houses or flats. It is a requirement of an assured short-hold tenancy, which is what most of these private lettings are, that the property has to be fit for human habitation when let and kept in a condition fit for human habitation throughout the tenancy. And it's an implied term of the tenancy. And if the tenancy doesn't meet that condition, it is at least in theory open to the tenant to repudiate the contract and say, well, look, you breached a term of it, landlord, I'm going to walk away. Is it possible that a property could be unfit for habitation because of its layout or provision of utility services during a pandemic? And in the Hong Kong case, they sort of allude to this and they say, well, it might be, but it didn't arise on the facts. So I'll give you an example. Suppose you are a student and you have rented a room with four other students in a property. They each have their own rooms. You've each got your own tenancy of the room, and there's 1 bathroom between you. Under the current public health regulations and indeed the guidance, if one of you got COVID, the whole household would have to isolate. And that's clearly quite difficult to do in a situation where you've only got 1 bathroom. Could it be said that facilities for washing and cleaning, which are otherwise adequate if everybody is healthy, become inadequate if someone has COVID, thus making the property unfit for human habitation? At least on the face of the Hong Kong judgment, the judge thought that was possible, albeit it didn't arise. And the interesting question I suspect in this country is, could you find a factual scenario where that argument was worth running? I can envisage one, albeit finding a factual scenario and getting a case to trial quickly enough to make it worthwhile is probably quite difficult. We've touched on this earlier as to, well, suppose there is frustration. Well, what happens in those circumstances? Well, the simple answer is the contract ends, and so does the rental liability. But the problem, of course, if the contract ends, is that so does the right to use the room. And this is what I alluded to earlier about, well, is this the answer you want, student? Do you want to use the right to lose the room? Because it seems to me there are 2 difficulties if you do lose the right to use the room. The first is, what if lockdown gets lifted and in-person teaching starts again? You'd have no right to occupy that property unless you could enter into a new agreement with the landlord or the accommodation provider. Where are you going to stay if you move back to your university? That may or may not be a problem in any particular scenario. I don't imagine there are masses of people rushing to rent presently unoccupied halls of residence. But if it comes to an end, you can't just move back. You would have to have some kind of fresh agreement. Secondly, and I think this is the more problematic one, what about all the property that's in your room? It doesn't matter for these purposes whether it's a halls style accommodation or whether it's a private tenancy. If you've got property in your room and your right to use the room comes to an end, you have to get your property out immediately, because otherwise you'd be trespassing. You can trespass through your possessions, you can trespass through your goods, you'd still be in occupation of the room because your property is still there. again, for any housing lawyers listening here, I know there's at least one. Cases like Islington and Boyle, you can occupy a property through your chattels. So what would you do if you decided to bring the contract to an end by frustration, but didn't go and pick up all of your stuff immediately? Well, it seems to me that A, you'd be trespassing, so you'd be liable to pay damages at the daily rate, which means at the daily rental rate. So it's not actually saving you any money because you've still got to pay the same rate in order to keep your property there. Or you've got to go and pick up your property, which you probably don't want to do because the reason you haven't moved back is because you don't want to travel around in COVID times. And your landlord probably becomes the involuntary bailee of your property, which means that he only has to give you a very limited notice under the Torts Interference with Goods Act, and then he can just dispose of it. You probably don't want to have your laptop, your iPad, or your books left behind, your university notes left behind, being destroyed by your landlord. Now, whether they do that or not is another matter, but it seems to me they'd be entitled to do so. So even if you did bring the contract to an end by frustration, you're still in practice going to have to negotiate some kind of arrangement, which you're going to have to pay for, I suspect, to enable you to store your property somewhere. So I'm not sure it helps enormously bringing the contract to an end. The one I think is more interesting is breaches of contract case. And these are where I do think some students, at least, are likely to have a bit of the upper hand. And if I were advising a student looking to negotiate with particularly with my university or my halls of residence, this is the way I think I'd do it. Depending on what the provider of accommodation is contracted to provide, I don't think it's unrealistic to suggest that many providers of accommodation are presently in breach of their contractual obligations to their students. Firstly, if you've locked the students out, then unless you as the provider of the accommodation can say it's frustrated, and I don't think it is for some of the reasons I talked about earlier, then that's a breach of contract. If I'm paying to use this room and you have locked me out of it, that is a breach of contract on your part. And I'm entitled to damages, or I'm entitled to elect to accept your breach and bring the contract to an end. But for providers of accommodation, it won't just be the provision of the accommodation in many cases. For catered halls, it's normally a part of the contract that there's food provided as well. Now, I've read quite a few of the contracts for different providers across the last few months. Some of them are absolute guarantees that they will provide food, which they're presently not doing, and therefore they are in breach unless they can say that the obligation to provide food has been frustrated. Better advised providers simply had a best endeavours clause to provide food. And they can say that they are using their best endeavours, they just can't get any staff to come in because of the COVID restrictions. But if you are in catered halls, it's worth looking quite closely at what the obligation on the provider is, because it will almost certainly be more than just to provide accommodation. It'll be accommodation plus something about the food. If the food isn't being provided, can you use that as the basis to argue that you shouldn't have to pay for the rent and you want to come to some kind of deal because they're in breach? They're not in breach of the clause that you think they're in breach of about the provision of accommodation, because it's still provided, but they're in breach of a different clause. And that's how you try and get into a discussion about finding a mutually agreeable position, either to be released or to pay a reduced rate during the period of lockdown. Again, though, the difficulty with all of this is if you're the student, if you bring all this to an end, what are you going to do if you want to go back? And what are you going to do about your property in the room? You can't just bring it to an end if you've got your own property in the room still. There are still things you need to think through. As regards private landlords, I think they're in a slightly stronger position here. It's very hard to see what breach of contract there'd be by a private landlord, unless the private landlord has actually locked you out. And my understanding is that's not what's happening. They're simply just not saying anything. They're saying the room is available to you, you're still the tenant, you've got to go ahead. If you use it or not, it's up to you. More likely, if you're a tenant of a private rented sector property and you're not in occupation, I think there's a real risk that you are actually in breach of contract, because it's normally a condition of an assured short-haul tenancy agreement that the tenant must be in occupation and can't be absent for more than a set period of time, usually 28 days. And the reason for that relates to the landlord's own insurance policies. The landlord normally has an insurance policy against damage, for example, if the place burnt down, and the insurance policy itself requires the landlord to ensure the property isn't vacant for more than a certain period of time. Now, the insurance industry cottoned on to this problem fairly early on in the pandemic, and many of the big providers extended the period of time that they would allow people to be absent for. But most only extended it to 90 days. And I suspect many people have had their properties empty for more than 90 days. So landlords are potentially in breach of their obligations to their insurance providers, so that if a problem arose, the insurance provider would be entitled to refuse cover. If the reason why they refuse cover is because the tenant hasn't been in occupation, then it would seem to me that the landlord is entitled to claim as damages his losses, his uninsured losses, arising from the tenant's lack of occupation. To give you an example that almost certainly will have happened over the last couple of weeks. In cold weather, it is almost inevitably the case that, given the poor quality of most of our housing stock in this country, pipes burst when they freeze, etc. If the pipe has burst, and during the time that it burst, the property was unoccupied, and it was unoccupied for more days than the insurance contract permits, insurance companies are entitled to just turn around and say, I'm not paying for the damage. If the reason why the landlord can't claim on the insurance policy is because his tenant is in breach of his obligations to be in the property, that's damage that the landlord can recover from the tenant. So if it costs, say, £10,000 to repair all the water damage, the landlord will be entitled to look to the tenant for that £10,000, or, more concerningly, I suspect, look to the tenant's guarantor for those £10,000, because in the private rented sector, as I'm sure most of you know, student lettings are almost invariably followed by a requirement that the parents give a guarantee, and the parents are normally good for the money because they own the property, so you go against the guarantor. There's also, this is probably more of a lawyer's worry than a real worry, but tenants who are leaving their property unoccupied for long periods of time potentially risk losing their security of tenure. It's a condition, a statutory condition of an assured short-hold tenancy, that you occupy the property as your own, your principal home. The longer you spend away from the property, the harder it is to maintain that it's your only, your principal home. Now, this probably doesn't matter, because the only real difficulty for a tenant if they lose security of tenure in this way is that the landlord could evict them by giving 28 days notice to quit, rather than by using the possession procedures, which are rather more demanding under the Housing Act 1988. And at the moment, I can't imagine many landlords want to try and evict their tenants. They'd rather their rent was being paid. And in any event, even if you want to try and evict, the backlog in the court system means that your prospects of getting a possession order this side of Easter are nil. So I'm not really sure this is anything other than a lawyer's concern, but it is just worth flagging up that students, the longer they spend away, may well lose their security of tenure. Where does all that leave us before I hand over to Admas? Well, it leaves us in a situation where, as I said at the beginning, I don't think there are any easy answers. I don't think there is an answer applicable to the whole sector. I think there are broad outlines of answers for broad outlines of classes. And I think the reality is that if a tenant approaches their landlord, or if a student approaches their halls provider and wants to negotiate, I think there is sufficient risk on both sides to mean that negotiation is the only realistic option. I don't think litigation is the answer, which is perhaps a very odd thing for a lawyer to say, given that that's what I do for a living. But realistically, you aren't going to get a case into a court and get a judgment to work out whether or not contracts have been frustrated so far. Even if you did it as friendly litigation with a really cooperative landlord who wanted to know the answer as well, you aren't going to do this in less than 6 months. So the prospects of getting any kind of answer that benefits anyone immediately, I think, are relatively remote. And in any event, as I've been saying at length, the answers tend to be quite fact specific. I don't think there is a general answer here. I would be more concerned, I have to say, if I were involved in this sector. I'd be more concerned about the position of guarantors, particularly in the private rented sector. I can see that I can see landlords who aren't being paid their rent, or landlords who are suffering other kinds of losses, finding it worthwhile to go after guarantors in these situations. And that's who I'd be more concerned about. My suspicion is if there is to be any litigation about this, probably won't be student against accommodation provider. It will in reality be parent who is either paying for the student's accommodation or is underwriting it with a guarantee, going against the landlord / accommodation provider to try and see if there's a way of reducing their own exposure. I'm going to stop there for a minute because I've managed to speak for twice as long as I originally intended to. And I'm going to hand over to Admas. Thank you very much for the questions that have been coming in. I'll have a quick look at those questions now and try and pick them up as we pick them up towards the end. So Admas, I'm going to turn my microphone off and hand over to you.
Thank you very much, Justin, and good morning, everyone. Just taking control of this slideshow. Okay, so the structure of my talk is going to be as follows. I'm going to just start with setting out some of the context in relation to issues that have arisen from the effect of COVID-19 and restrictions imposed in response to it on the student accommodation situation. And then I'm going to deal really with two legal issues that arise. One, the more discrete, is to do with international students and whether failure to pay rent raises any issues for universities as sponsors in terms of something they might have to notify the Home Office about. And then I'm going to talk about rent strikes, which is a slightly meatier topic, just to try and flesh out what the legal position is on rent strikes. So just to start with setting a background to where we are, I've got a quote there from the House of Commons Library. Residential higher education is described as something that's entrenched in English culture, and that leaving home study is considered to be an important part of the higher education experience. In the last, using figures for the last available year, the majority of students live away from home. About a fifth live in halls. Just under a third live in private accommodation, which are mostly houses in multiple occupation. I've just set out there a timeline of the guidance from the government and from the Minister for Higher Education over the period of the lockdown. And obviously the the government's position and responses have varied in response to developments in the pandemic. And so we see there how the messages to students have changed over time. At certain periods, it's been to stay in their student accommodation, and the last indication given in February, or the position as of February, is that it's only a limited number of students studying a small number of subjects who are to physically return to university, with the remainder staying where they are. And the message from the Minister for Higher Education in February was that the return and arrival of other students should be postponed until at least the 8th of March. So something is apparently going to happen on the 8th of March. In terms of, it's well documented that this has raised issues for students in terms of, their not being able to use their accommodation, yet still having to pay for it. And some university-owned halls of residence have allowed students who have left their accommodation due to COVID to terminate early without any charges, despite, in some cases, there not being really any provision in the licenses for that. A number of student accommodation management companies had waived fees for the 1920 academic year if a student vacated their accommodation. And there are also reports of similar approaches being taken by rental agencies and private landlords. Another part of the picture, of course, is that many students while at university would rely on part-time work to fund their living costs, and many are unable to do that in present circumstances. So that's the situation. In terms of its effect on universities, according to Universities UK, the university sector in 1920 faced losses just of around £800 million from accommodation, catering, as well as conference income. And included in that is additional spend to support students online. That's obviously a very significant sum, and Universities UK highlighted a risk of some universities having to close, others having to reduce provision or research activities in view of that cut in income. From the student side of things, there have been reports, particularly last month, of potential rent strikes in Wales and in England. Earlier last year, the National Union of Students called for the government to instruct university-owned and private-owned accommodation providers to offer releases to tenants, to student or licensees rather, more accurately, in view of the effect of restrictions. And I checked the count on this last night, and around 80,000 people have signed a petition that was started earlier last year, but still open, that calls for the suspension of student accommodation rent for those students who had to return home due to COVID-19. And the issue's been picked up by the government in a letter from the Minister for Higher Education in January in last month. It was said that students understandably are publicly questioning whether they should be entitled to accommodation cost refunds, and the government stated that it was looking at what could be done to assist those students. So it's very much an issue that has generated significant public interest, including at the highest level of government. So that's the background. So I'm going to come on to rent strikes in a moment, but first, just to deal with one issue, quite a discrete issue that arises in relation to international students who may technically under their contracts, under the contracts, be in arrears of payments for their accommodation. And so the question is, does this raise any issues in the immigration context, given that the university has a role as a sponsor in relation to those students? So the context is, or the legal context is, that in order to obtain a student visa, applicants must have been accepted as students within an institution that is registered as a licensed student sponsor. Such sponsors, such as universities accepting international students, are subject to a range of duties in relation to record keeping, systems, and appraising the Home Office of changes to the situation of their international students. And there's a range of guidance produced by the Home Office that sets out the duties and other aspects of the framework. And particular relevance is the guidance document, student sponsor guidance document number 2, sponsorship duties. And these documents are all available online. In terms of the approach taken by the courts to the Home Office's supervision of sponsors, it's worth bearing in mind that the Home Office has a pretty wide discretion to revoke licenses where it considers there has been a breach. The position has been described in the following way. In the Cranford College case, it was said there is a high degree of trust in the educational establishment concerned to fulfill its responsibility to implement and police immigration policy in relation to international students. And because of that, it was said in that case, and it's been consistently, and this approach has been consistently taken by the courts, that the Secretary of State is entitled to expect a very high degree of vigilance and is entitled to maintain a fairly high index of suspicion in how they oversee institutions, and a light trigger in deciding when and with what level of firmness they should act. So it's quite a broad latitude it's given to the Secretary of State in regulating sponsors. That's an important part of the context. Now, under the guidance, sponsors must inform the Home Office if, for example, a student withdraws from a course, misses a certain number of classes, or is withdrawn from a course by the institution, or there is a significant change of circumstances. These aren't this is not an exhaustive list of when sponsors must inform the Home Office, but it's these are included in the situations. So what is a significant change of circumstances? Well, according to the guidance, these include a change in the place of study or the work placement, a change of course, or anything that suggests that they are breaking the conditions of their permission to stay in the UK, such as working in breach of their conditions. So, is there any duty to report the fact that an international student is in arrears with accommodation payments? Does that arise from any of the guidance that is out there? Well, there's nothing specifically to this effect in the guidance. That's the first point to be noted. And it would appear that probably there isn't a duty. There's no express duty, but also in circumstances where the sponsor is otherwise clearly complying with its duties, and it remains clear that the student is in fact studying the course that it was intended they should study, it would appear there's little to justify interpreting the sponsor's duties in that way. And it's important to bear in mind that we can infer this to an extent from the extract cited earlier. The justification for the duties that are imposed on sponsors is protection of the efficacy of the immigration control system, and also controlling the risk of sponsors facilitating fraudulent applications following some incidents in the early noughties. So the fact that because of COVID-19 related issues, an international student is not paying for their accommodation because they're not using it, certainly would not appear to me to fall within that broader justification. So that's the immigration issue. It's quite a discrete issue. I'm now going to talk about rent strikes, which raise some interesting legal issues. Is there a legal right to go on a rent strike? Here's a selection of a few examples of successful UK rent strikes. My favourite probably those that occurred in Glasgow at the turn of the century, where bailiffs were pelted with flour bombs. Those strikes were pretty successful. They spread throughout the UK and actually led to the introduction of legislation. And there are a couple of other examples there, including quite a recent one in 2015-16 by UCL students. So to return to our question, is there a legal right to go on a rent strike? Well, the short answer is there is a significant risk of tortious liability for engaging in a rent strike. And there is the possibility of reliance on human rights, but it's not a guaranteed justification. So let's just go through those issues to see, unpack what's going on there. In terms of an individual tenant deciding to stop paying rent in protest at some issue connected to their tenancy or their license, the risk there is obviously a claim for the arrears or the license payment and for possession of the property. In relation to organised action by a group of tenants or occupiers under a license, there's a risk of tort claims in two ways. There's a claim in unlawful means conspiracy. I'm going to explain what that means in a moment. And there's also a claim for procuring or inducing a breach of contract. And those are both what we call intentional torts. So going through each in turn, unlawful means conspiracy sounds very serious. What does it mean? This arises where two or more persons combine and take action which is unlawful in itself, with the intention of causing damage to a third party who does incur the intended damage. So causing damage to a third party, well, that would include loss from a breach of a contract or a license. So if you have a group of people combining and deciding that they're all going to stop paying rent or stop making payments under their license, each one is together engaging in a plan, a conspiracy, the effect of which is going to lead to the result that the landlord or the licensor is going to lose payments that they're entitled to under their license or their contract. There's a question as to whether a breach of contract or breach of a lease term is unlawful for the purposes of an unlawful means conspiracy. There's no case law that I could locate directly on this point. The authors of Clark and Lindsell strongly suggest or take the view that it would satisfy the requirement, and certainly in the context of other torts, the tort of intimidation, for example, the risk of a breach of a contract or to threaten a breach of contract has been found to be unlawful to found a claim in that tortious claim. So it seems, it's not completely clear, but it seems it's reasonably likely that that situation would give rise or could give rise to an unlawful means conspiracy. So that's one problem in terms of tort for those who wish to engage in a rent strike. The second is in the tort of inducing or procuring a breach of contract and the risk of liability under that. It's a tort to induce or procure a third party to commit a breach of contract, and justification is a defence. The breach of contract here would be not paying rent due under the licence or the tenancy. The classic case for this cause of action is Lumley and Guy, which was a dispute about a well-known opera singer, Johanna Wagner. It's a picture of her there, a niece of Richard Wagner, apparently, who contracted with one person, Mr. Lumley, to perform exclusively at his theatre. Mr. Guy then enticed and procured Johanna Wagner to refuse to perform at the Queen's Theatre and thereby break her contract and perform at Mr. Lumley's theatre instead. And the court held that Mr. Guy was liable to Mr. Lumley for procuring a breach of contract. So the general position in English law has been that strikes give rise to liability under this tort, because if you're engaging in a strike, you're generally trying to achieve an object that is a breach of a contractual arrangement. In the case of rent strikes, it's obviously the payment of rent. You're withholding rent that the landlord is entitled to, or in the more common example of trade or employment related disputes, you're withholding labour that the employer is entitled to under the employment contract. Strikes by trade unions are lawful only because they are exempted from liability under this tort by statute. And the relevant statute, the relevant provision is section 219 of the Trade Union Labour Relations Consolidation Act 1992, which provides that subject to meeting a range of statutory requirements, there's an exemption for strikes which are done in the context of in furtherance of a trade dispute. So that's the general position. In the case of Camden nominees and Forseen Bennett, those principles were applied in the context of a rent strike by tenants of Highstone Mansions in Camden. That's Highstone Mansions in Camden today, right by Camden Lock. So in this case, the tenants formed a tenants association in response to a range of issues with the landlord, including a lack of sufficient heating in the building, and then withheld rent for what they said were breaches of their respective tenancies with the landlord. Mr. Justice Simons held that the chair and secretary of the Tenants Association were liable in tort for inducing or procuring a breach of contract. That decision wasn't appealed, and it hasn't, so far as I've been able to see, been subsequently doubted. Therefore, it's still to be considered technically good law, but we'll have a slightly closer look at it in just a moment. So the starting position is there a right to a rent strike? Just excluding human rights for a moment, the answer would seem to be a pretty clear no. An individual tenant faces a risk of an order for rent possession, as mentioned. In conspiracy and inducement claims, where you have an actual strike with a group of people, the landlord could seek an injunction, but also claim for loss arising from the contract or contracts. And with a large rent strike, that could be a significant sum of money. They need not target every participant in the rent strike. Indeed, as in the Camden nominees case, they may consider it more effective to target the leaders of the rent strike, where their case would also be the strongest. Furthermore, it's worth noting that international students who intend to make another application for leave to enter or remain could face difficulties if they have a judgment entered against them, and particularly where they don't pay that judgment promptly or at all. The Home Office's guidance provides that where a person deliberately and recklessly builds up debt and there is no evidence of a serious intention to pay off, they should normally be refused leave to enter or to remain. So that is an important consideration for international students. So that's the bad news for those wishing to go on rent strike. But are there any legal arguments available to strikers? Are we really stuck with the law as it was in this one case in 1940? It seems to me there are three possible issues that arise. Two are in relation to inducing a breach of contract. What does inducing or procuring actually require? And will organising a rent strike necessarily meet that threshold? Can a rent strike be justified? In either case, if you don't meet the threshold for inducing or procuring, or if a rent strike can be justified, then there's no liability. And then secondly, what's the relevance of human rights? So going back to the Camden nominees case, what was the procuring or inducing? What exactly was it that the leaders of the Tenants Association are said to have done? Well, they produced two letters, and there was a general meeting, and there was also a report that was produced. So looking at those in turn, the first letter was that sent out to the tenants proposing the association. And it said that it is the intention of the association to approach the landlord and insist on the maintenance of proper services. There was no reference made to withholding rent in that first letter. Subsequently, there was a general meeting, and in that meeting it was resolved that the committee should send a letter setting out the tenants' complaints, which were common complaints, and failing remedying of those complaints, the rent should be withheld. So that was agreed at the general meeting. The second letter was drafted by the association, but then sent out by each of the individual tenants, and it was advising the landlord that rent would be withheld following the landlord indicating that they wouldn't respond to the approaches by the association and would not recognise the association. And that letter was sent by 16 tenants. Lastly, the Tenants Association produced a report which it issued to all tenants. It advised tenants to inform the association if it were visited by the landlord in relation to the dispute, and deprecated what it termed the landlord's divide and conquer tactics. And the report also said that it hoped tenants will stick together in accordance with the democratic resolution, and asked tenants to inform the association if they had not notified the landlord they were withholding rent pending resolution of issues. I.e., let us know if you haven't yet inform the landlord you are withholding rent. So that was found by the judge in the Camden nominees case to constitute inducing a breach of contract, not by the leaders of the association themselves, but by the other tenants. Now, the first thing that's interesting about the judgment is that the cases cited by the judge in support of his conclusion all involved situations where there was a significantly stronger degree of involvement by the defendant in inducing the breach of contract. I've just listed a few there to give a flavour of that. So in the Glamorgan Cole case, which went to the House of Lords, there was a dispute whether the defendant, which was a miners' federation, had merely advised the miners to strike. And there the court said that this so-called advice was much more than counsel. It was accompanied by orders to stop, which could not be disobeyed with impunity. So it was in the nature of an order to the miners who actually breached their contract. Another case cited Smithies involved a situation where a union sanctioned the strike, so gave its approval for the strike. A third case cited, which involved the British Medical Association, that was a case where the British Medical Association had itself boycotted a member of the association, leading parties in contract with that member, the doctor, to break their contracts. And then a fourth case cited, Brimelow and Casson, that involved the defendant, an association which protected the interests of actors and showgirls, directly inducing the contracting parties, which were theatres which had contracts with the tour operator, with the theatre operator, to breach the contract. In one case, they actually made such a theatre give an undertaking not to put on the show. So they took quite strong positive action to bring about a breach of contract. Now, it might be thought that the position in the tenants case is a little different. And it really, what it brings into focus is the question of how far does somebody participating or organising a rent strike have to go before they can be said to be inducing a breach of contract? It seems reasonably widely accepted that simply giving advice won't suffice. So if I'm asked to advise someone about the lawfulness of a rent strike, and I give advice that, well, in light of the European Convention on Human Rights, there's some prospect, there are good prospects that this won't be found to be unlawful, I can't be taken to be inducing a breach of contract. But the law has drawn a distinction, or sought to draw a distinction, between persuasion and advice. This is illustrated in the second extract on the slide, the D.C. Thompson case, which refers back to the Camden nominees case. And there the judge said there is a difficult question of distinction between what might be called persuasion and what might be called advice, meaning by the latter, advice, a mere statement of or drawing of the attention of the party addressed to the state of the facts as they were. In the case of Camden nominees, it was held that the advice given was of such a nature, that is, was of a character obviously intended to be acted upon, that it was for all practical purposes equivalent to persuasion. And it's also clear that merely facilitating someone's ability to breach a contract isn't enough. It's got to go beyond advice, it's got to go beyond facilitation, and it's got to be persuasion. And that's been affirmed quite recently in a Court of Appeal case that came out last month, where the Court of Appeal made the point that the persuasion must be causative. There must be a causal relationship between it and the breach of contract. So it seems reasonably established, but the question we might ask is this a cogent distinction between persuasion and advice? Where does one draw the line? If one is simply making somebody else aware of the possibility of doing something and explaining, talking through its ramifications, well, it seems to be that would be advice rather than persuasion. So where does the difference arise? Does it arise in the effect that it has? Well, that can't be right, because it may be that making somebody aware of a possibility and explaining the ramifications of it is simply the information they need to make a decision about what they want to do. Now, why in that case should the law hold the person who explains the situation and the possibilities to be liable? One of the bases on which inducing a breach of contract was introduced as a cause of action was by analogy with accessorial liability in criminal law. So if you conspire with somebody to commit a criminal offence, the law will take you to have also committed the offence, even if you don't actually carry out the deed itself. So it's on the basis of that analogy. So there's a question to be asked as to at what point the line is to be crossed in these situations. And an issue that's not considered very much at all in the case law is how all this plays out, where you have a group of people who have common but individual contractual obligations, such as the Tenants Association in the Camden case. Now, each of those individuals had tenancies with the landlord, and they were engaged in a discussion which was of common interest to all of them. And it seems, at least to me, that in the Camden nominees decision, that's not really an aspect of the facts that was given the relevance that it deserved. This wasn't, most of the case law on this involves disputes between competitors. So a competitor inducing a breach of contract in the employee of another competitor, and thereby gaining a commercial advantage. And the principles are shaped really to deal with situations of that kind. And there is a question as to whether in these situations where people are coming together to deal with a common contractual problem, but that affects each of them individually, and where they all have individual contractual relations, that a different approach may be called for. The second potential issue under inducing a breach of contract is justification. And inducing a breach of contract is not unlawful if it's justified. And there is very sparse authority on what exactly constitutes a sufficient justification. It's pretty clear that protecting an equal or superior contractual right of your own can be justification. In Brimlow and Casson, that was a case where the act of association induced a breach of contract, where the wages paid to chorus girls were below the minimum wage fixed or recommended by the association. And that was a case where the judge found there was justification for the breach of contract on the basis that the actors association owed a duty to their calling and its members to take all necessary steps to compel the plaintiff to pay a living wage. That decision wasn't appealed and hasn't been deprecated, apart from in Camden nominees, where Mr. Justice Simons appeared to criticise the conclusion. But the short point on justification is that the law is pretty wide open. There isn't much in the way of principle to guide a judge looking at this issue. So it's a potential pinch point in terms of the development of the law just on the basis of tort. The last potential issue in terms of providing for a legal basis for a right to strike, and it might be thought the clearest, is human rights, and in particular Article 11 of the European Convention on Human Rights, which is given domestic effect by the Human Rights Act of 1998. I've set it out there in full. What's particularly relevant here is freedom of association with others. So that's the point we want to note. And then the second point to note is this is what's termed a qualified human right. So paragraph 2 provides for the situations in which it can be restricted. And a court looking at a alleged contravention of Article 11 will need to weigh up the importance of the right in question with a range of factors listed in paragraph 2, including whether the interference is necessary in a democratic society, the interests of public safety, prevention of disorder or crime, or the protection of the rights of others, which is likely to be the relevant hook in the rent strike context. The right to strike is widely recognised as an element of the freedom of association. It's been recognised by the European Court of Human Rights and in a number of other international instruments to which the courts here and the European Court of Human Rights will have regard when interpreting the ECHR. Now, as I mentioned, it's a qualified right, therefore interference with it can be justified. There are a couple of examples there. In the National Union of Rail Maritime Workers case, that was a ban on secondary strike action, which was held to be justified. In the Association of Academics case, the European Court found that legislation banning strike action in the healthcare sector was justified on the grounds of its likely effect on patient care. I wasn't able to locate anything in the context of rent strikes, but there is one point which is, well, there are 2 points perhaps which are noteworthy. First is we're dealing here really with conflicting private law rights. So there aren't the kind of broader public interest issues that arise in a case such as the academics case, where permitting the strike would have an effect on, for example, the ability of the hospital to care for everyone that comes in. On the other hand, the question of the weight that's going to be attached to the strikers themselves, if they're students, a lot of that will be quite fact sensitive and will depend on the way in which the strike is framed and what is said to justify it. So that's one point that goes to the nature of the rights and the nature of the countervailing interests. The second point is that in many of these cases, heavy weight is placed. Many of these cases involve challenges to legislation, and so heavy weight is placed on the democratic legitimacy of the institutions that have made those laws, and the fact that they have, in making such laws, imposing such restrictions, weighed public interests and come to a judgment on where the balance should be struck. And the general view of the courts, both domestically and in Strasbourg, is that there should be a great deal of latitude given to such institutions when they make such judgments. That's not the case here, because we're not dealing with a piece of legislation that's been passed by Parliament. Rather, we're dealing with a principle that's been developed by the common law in relation to inducing a breach of contract and also conspiracy. We're talking about tort actions which have been developed by judges, by the judicial branch, to regulate private relations. And so it seems to me that the proportionality arguments in those situations might be a little easier, because that obstacle of democratic legitimacy and of the institution having that legitimacy to strike the balance do not arise to the same extent. So that could prove potentially fertile ground for development of the law in that respect, and in moving the law beyond where it has got to with the Camden Nominees case in 1940. So that brings to an end my talk, and I think Justin hopefully will rejoin us at some point, and we'll be able to start looking at some questions.
Yeah, I'm back. Thank you very much. Do you want to open up the question tab and have a look? I think the 4 or 5 at the bottom are for you, and I'll pick up some of the ones that relate to my bit. So I'll buy you some time to read them and figure out what you think the answer is. Thank you for the questions that have come in. We've got 10 minutes or so we'll try and get through as many as we can. There's quite a few that are very fact specific. And indeed, in one case, you've actually been honest enough to tell us that it relates to a case you are bringing in the small claims court. For obvious reasons, I am not going to talk about fact-specific cases, and I'm certainly not going to talk about a case that's just about to be decided by a judge, because if I get it wrong, you could sue me. I'm happy to talk about things in very general terms, but otherwise, I'm afraid in order to ensure that my insurance company don't come down on me like a ton of bricks, I'm going to keep this quite general. There are various different ways of putting an argument about frustration, as we talked about earlier. And it's true, as a couple of questions have pointed out, there are other arguments you could try and run. You could try run an argument about rent waiver, for example, that whether expressly or impliedly, if mainly in relation to halls accommodation, if the accommodation is provided because it's an essential part of the learning experience, and it's not provided, but the learning experience continues, has the obligation to pay rent or to pay a license fee been waived? Sure, I can see that argument. Just like I can see the argument on all the frustration bits, and I can see the argument on breach of contract. My concern with all of these is they're going to be fact specific. B, getting in front of a judge in order to get a decision that's going to be of any use to anybody apart from the litigants seems to be quite hard. So, for example, for the individual who's written about their own small claims case, obviously, I hope you get the result that you wanted. But at the risk of stating the obvious, a small claims judgment sets no precedent at all. If what you were looking for, and this is what I'm looking for, because I'm trying to find answers that help as many people as possible. What we really want is someone to find a way of getting in front of a high court judge or a court of appeal judge and trying to have a discussion about the broader principles. And that's hard because, as we talked earlier, all of these cases are so fact specific. Likewise, a couple of variants about what happens with the student being overseas. Does it matter when they went overseas, etc., etc.? Look, again, I know this isn't the answer anybody wants to hear. It might. If you went overseas at a time when there was absolutely no reason to believe there'd be any kind of lockdown, then I think that's a very different position than if you go overseas today when you know that the government is talking about introducing a quarantine stage. I appreciate that's not an answer that helps you very much, but I think that's as far as you can usefully go without knowing any more about the individual facts of any individual case. What about other facilities that are provided as part of the student accommodation, not just the bedroom and the cooking facilities like gyms and communal spaces, or even a bar, apparently in one case? If those are closed or inoperative, yeah, that might be a basis for running some kind of argument about either a breach or a basis for negotiating a reduction or a waiver. You need to see what's actually agreed to be provided and what the nature of the agreement is. Is it we will provide a gym, or is it we will use best endeavours to produce a gym, or to provide a gym, or reasonable endeavours to provide a gym? Because all of these things have different meanings. This is why I say it's very frustrating, and it lends itself to individual answers, not to proper answers you can apply across the board to people. What about, do you want to pick up, Admas, the question from 1152 about sponsor obligations for overseas students?
Yes, sure. So the question is, if overseas students are not physically at university but studying remotely, is it fair to say universities must know where they physically are? I think I should say, if in the UK. I don't know if there's anything in the guidance that says that specifically. I think we can split up you can look at the obligations on 2 levels. One is what is specifically said in the guidance, specific things that a sponsor is required to keep abreast of, and that's not in that category. And then in the second category, one can put oversight over students of a general nature and where the Home Office is concerned about the student sponsor, or has good reason for other concerns, it may ask questions about that. There are kind of more general systems and duties. I'm not familiar enough with university administration to give a definitive answer, but I would guess that universities would generally know that, but that's just conjecture really from me.
Any more? Let's have a quick look through.
There's another question.
What about that last one about the inducers being liable for losses?
I was going to say it. Yeah, so two very interesting questions at the end. First, if the inducers are liable for loss arising from a breach of contract, does that mean a tenant are not, or are they equally liable? I don't think it affects the liability of the tenant. I think the tenant remains liable. Justin will tell me if you want.
No, I think that's right. I mean, the obligation to pay rent or to pay license fees is always a personal obligation. I was wondering if you, this is probably just my showing the way my mind works, if you were a tenant who was induced by a third party not to pay your rent, and the landlord then sued you for your unpaid rent, could you claim an indemnity from the person who induced you? Probably not, because what duty do they owe not to induce you to break your own contract?
Yeah. Well, that's the second question that's asked here. Actually, can tenants make a claim against those that induced them to breach a contract? I'm not sure they can, because I don't think they've committed a tort vis-a-vis you, because you're not, unless what's your how they injured you. It's your breach of the contract that's, if anything's going to happen to you, it's because you breached the contract. And you can't, it doesn't, well, this is part of the problem in a way. The fact that they've persuaded you or such like doesn't really negate the fact that you've breached the contract. I mean, you breaching the contract is an ingredient of that. You still have agency. You're still liable. So certainly my instinct is no, absent something unusual.
Yeah, I think I'd agree with that. I think that's probably a good time to wrap this up then, because we've only got about 4 minutes left until we've used up our hour and a half, which given that we had an hour and a half when there was going to be Fiona joining us as well, and you and I have managed to fill it, I think we should probably end this there then. So thank you very much, everyone. What will you'll get an email later on today, possibly tomorrow, depending on how efficient we are internally. It will give you a link to a recording of this, and attached to that will also be details of the slides if you want to download those and have a look. Otherwise, thank you very much for giving up your mornings, and I hope you all have a very nice lunchtime. Thank you. Bye.